Now, President Cyril Ramaphosa has signed into law the Second Adjustments Appropriation Bill and the Electoral Matters Amendment Bill. The Presidency says the two bills seeks to expand financial resources for South Africa's multi-party democracy, including support for independent candidates and representatives. Now, in particular, the Electoral Matters Amendment Bill will amend the Political Party Funding Act of 2018 to provide for the regulation of the private and public funding of independent candidates and independent representatives, among other provisions. Now, to help us understand these bills, we're now joined via video link by former Vice Chair of the IEC and founder of Institute of Election Management Services in Africa, Mr. Tselane. Terry, thank you so much for your time this afternoon. So help us unpack this. The two bills were but one of many bills we know, that were awaiting President Cyril Ramaphosa's signatures. Now, with the Electoral Amendment Bill, a key feature we understand is of the new law is the provision for independent representatives to access financial support from the multi-party democracy. Now, talk to us about the two bills and how significant this is then to the political funding model and, of course, the allocations to political party funding.
Good afternoon to you and to your viewers, and thank you very much for having me. The Electoral Amendment Bill, now the Act, is important in terms of regulating the framework within which the political parties can participate together with the independents in the elections. You may remember that in the past, you had an arrangement where only political parties could benefit from the Party Funding Act. Now, with the Constitutional Court judgment, which basically allowed other South Africans to participate in the elections as independents other than through membership of political party, it ushered in a new period within the South African history, which basically meant that the Act had to be amended in order to give an expression for the participation of independents in the process. But what has happened is that the Parliament, did not only change the arrangement to include independents, but they changed the whole scheme of party funding. In the past, you may recall that the system that was being used there was for two-thirds, for money that was allocated by Treasury to be shared in terms of two-thirds according to the number of seats a political party has, which meant proportional to the number of seats a political party had. And then two-thirds of that being for what we call equitable distribution to political parties. Now, that has changed. We have gone back to where we started when the Party Funding Act started, where now 90% of the money would actually be proportional to the number of seats, and 10% would then be allocated equitably to everybody, including independents that will be participating in the elections for the first time. So that is the major thing that has actually happened. But also remember that there was a threshold that if you passed, if you got funding that was more than 100,000, there had to be declaration of that amount. But also that no donor could actually donate to a political party anything more than 15 million. Now that has changed, so there's no longer a threshold of 100,000, and there's no longer also a limit of 15 million within which the political party had to operate. So the new arrangement, the president decides only with the concurrence of Parliament, or after Parliament has actually made a submission in terms of the threshold as well as the limit within which a political party can receive money. But at the moment, it means there's no limit and there is no requirement for declaration.
And now, I mean, just in terms of the independents themselves, I would imagine that this is somewhat of a relief.
Yeah, well, it's a minor relief for them because at least they're going to benefit from the system. But remember that they don't benefit from the proportional distribution of money because they're coming as independents, and therefore they would only qualify in terms of equitable distribution portion.
And Terry, just before we let you go, of course, I want to just get your sense in terms of, just heading up to, the elections. I mean, let's talk about a little bit about the IEC. I mean, as the former vice chair of the IEC yourself, I would imagine that you have a view in terms of how the IEC is currently navigating this terrain, leading up to the elections. We know, of course, of several court cases on the cards, including the Apex Court. Just your view in terms of, how it's going for the IEC, particularly as it also comes under harsh criticism.
The Electoral Commission has got to appreciate the significance of this moment in terms of the decisions that they take going forward. This is a very complex terrain, and unfortunately also the period within which these elections are going to take place is compressed. I would have thought that the president would announce the results, or rather the date of the elections to be on the outer portion of a period within which the elections are supposed to be taking place, which is 90 days. And I thought it was going to be at least around the 31st of July. This would have allowed the Commission to prepare for a smooth election. But we are working on the basis of the 29th of May, lots and lots of pressure. There are issues that are supposed to be finalized at the Constitutional Court, and then some of them have got implications in terms of the production of the ballot paper. If the Constitutional Court decides, therefore, that the parties, particularly parties like Labour Party, have got to be included in the in the ballot paper, that would actually have implications in terms of the capacity of the Commission to prepare and make sure that we receive the ballot paper as per the plan on the 29th of November. I would have thought, if I were part of the Commission, I would say they should actually work on Plan B, which is to invoke Section 21 of the Electoral Act, where they can ask the President to postpone the elections, or the Premiers also to postpone the elections. But that postponement, as I've indicated, must still be within a period, within 90-day period, which is the constitutionally stipulated period. There are quite a number of difficulties that the Commission has got to deal with, and then hopefully they will not be making any elementary mistakes that will make people to have excuse about the credibility of the process.
And I think a lot of people would actually agree on that point, just given the complexity and the challenges that are facing the IEC, particularly as it relates to the courts. And again, speaking directly to its credibility, should the Apex Court not rule in their favor in terms of, just the workload that stands before them. But Terry, that's where we end our conversation. But thank you so much for your time. Really do appreciate you coming on.